So friends, in Donald Trump's first criminal trial, scheduled to kick off in just a little over 2 weeks now, the judge just entered an order to try to protect the jurors from Donald Trump and his supporters. Let's talk about that, because justice matters. Hey all, Glenn Kirshner here. So friends, Donald Trump's first criminal trial, his first prosecution, is scheduled to kick off on March 25th. And the presiding judge in the case, New York State Court Judge Juan Merchan, just ordered that the jurors will be anonymous and that Donald Trump and his lawyers may not disclose their identities to anyone. Let's start with the new reporting. This from NBC News. Headline: Judge restricts access to jurors' identities in Trump hush money trial. And that article begins, the New York judge presiding over former President Donald Trump's hush money case ruled Thursday that he'll use an anonymous jury when the case goes to trial this month. While Trump and attorneys in the case will know the identities of the jurors, their names will be shielded from the press and the public, Judge Juan Merchan said in his order, citing, get this friends, a likelihood of bribery, jury tampering, or of physical injury or harassment to the jurors. The judge said his order applies only to jurors' identities and addresses, and had been requested by prosecutors from the Manhattan District Attorney's Office and consented to by Trump's attorneys. And this quote from Judge Merchan, quote, to be clear, the parties have not requested, and this court has not agreed, to close the courtroom during jury selection or at any other time during the proceedings. Access to the courtroom by the public and the press will not be tempered in any way as a result of these protective measures, Merchan said. He, the judge, also granted a request by Trump's attorneys to minimize potential prejudice to their client by not notifying the jurors of the protective measures and giving neutral explanations if they, the jurors, ask about them. He asked both sides to jointly submit proposed neutral explanations by March 15th and said if they can't agree on language, to file separate suggestions by March 18th. The Manhattan DA's office had also asked Merchan to warn Trump that any harassing or disrupting conduct that threatens the safety or integrity of the jury may result in forfeiture of defendants' access to juror names. The judge said he will rule on that issue when he decides on the DA's request for a partial gag order, barring Trump from bashing witnesses and court staff members in order to protect the integrity of the criminal proceeding. Trump is charged with falsifying business records related to hush money payments that his then attorney Michael Cohen paid to adult film star Stormy Daniels in the closing days of the 2016 presidential campaign. Trump has pleaded not guilty in the case, which will be the first of 4 pending criminal cases against him to go to trial. So friends, I have 3 quick thoughts about this development. First of all, the article says this is a hush money payment and falsifying business records case, but to this old prosecutor, what's most important about this case is the motive. Why did Donald Trump make hush money payments, and why did he then falsify business records to cover up the true nature of those hush money payments? It is because the motive in the case was to interfere in the 2016 presidential election by committing 34 felony crimes of falsifying business records to cover up the true nature of the hush money payments. thereby robbing the American voters of the full value of their vote, because he buried deeply damaging information about his unsuitability to be president. So, yeah, this is an election interference case, and it's the first criminal trial of Donald Trump for interfering in a presidential election, the 2016 election, and one of his subsequent trials will be for Donald Trump interfering in the 2020 presidential election. Actually, two of his subsequent trials, because he's charged criminally in federal court in D.C. for trying to overturn the election's results, and he's charged as part of a RICO conspiracy case in Georgia for trying to interfere in his election loss in the state of Georgia. Second point, this jury will be anonymous. So Donald Trump and the prosecutors will not be permitted to disclose their names, their identities to anyone. That's unusual, not unprecedented. You may have heard me say in the past, and I'm only going to spend a minute on this, that in my 30 years as a federal prosecutor, I only had 2 cases with anonymous juries, and each one was a RICO prosecution of what was probably the most dangerous criminal organization in Washington, D.C. They were so dangerous that the judge ordered that those jurors would remain anonymous in those 2 cases. And now those extraordinary juror protection measures have to be put in place for the criminal trial of a former president of the United States. Third, there is that one curious passage in this article where we learn that Trump and his lawyers requested that the judge not tell the jurors that these security measures are being put in place to, quote, minimize the potential prejudice to Donald Trump. If the judge was to notify the jurors, and if the jurors asked questions about what these protective measures are all about, that the court give neutral explanations. In other words, kind of hide the true nature of why the judge feels compelled that he has to protect the jurors by keeping their identities shielded, keeping them under wraps. What's going on there? Because that might strike you as curious. Well, here's what's going on there. Anytime you have a case with a particularly dangerous defendant, such that jurors may be at risk, just as witnesses may be at risk, just as with Donald Trump, we've seen that judges and their staff members are at risk. Prosecutors and their team members are at risk. Everyone is at risk if they are involved in the endeavor of trying to hold Donald Trump accountable for his crimes. But here's the thing. Anytime you have a criminal case like that with a particularly dangerous defendant, you try very hard not to inject into the minds of the jurors that they might be at risk because they are sitting in judgment of an especially dangerous defendant. That's a reality in the prosecutions against Donald Trump. But there is a risk that the jurors might start to decide the case based on their own security concerns rather than based only on the evidence they see introduced during the course of the trial. You don't want the jurors, if you can prevent it, you want to protect them first and foremost, but you don't want them to begin thinking about their own safety, their own security concerns, because there's no way of telling how that might cut. Maybe they'll say, I'm so scared of this defendant that there's no way I'm going to vote guilty because then people might come after me. Or they might think, I'm so scared of this defendant, he's so dangerous, he's even endangering me, that you bet I'm going to vote guilty. Neither one of those two motivators is appropriate. So you try very hard to create circumstances and create an atmosphere and create proceedings where, the jurors are not thinking about and hopefully not obsessing about their own security concerns. And that's why you saw that passage in the article where Trump and his lawyers said, please don't tell the jurors that they're anonymous. Don't tell the jurors you're putting these security measures in place to try to protect them, because then they might hold that against Donald Trump. The prosecutors might say they'll hold it against the prosecution because they'll be afraid to convict Donald Trump. And then, as you heard in the article, they went one further step and they said, well, if the jurors start to ask about those things, the security measures, just give them a neutral explanation, and the parties are going to propose language of what that neutral explanation might look like, something short of telling them what's really going on here. Because what's really going on here is Donald Trump is forever running his mouth, posting things, saying things that endanger witnesses and jurors, judges, prosecutors, and their staff members. That is what Donald Trump has done from day one. Go after his perceived enemies, the people who are trying to hold him accountable for his crimes. But it looks like Judge Merchan is trying to strike the right balance, protecting the rights of the defendant, to have his case decided only on the evidence introduced during the course of the trial and not extraneous information like fear that jurors might experience. And these are challenges for judges to navigate. But by all accounts, Judge Merchan is up to the challenge. Remember, he's the judge who presided over the criminal prosecution of Donald Trump's organization, the Trump Organization, and the prosecution of Donald Trump's criminal chief financial officer, Alan Weisselberg, right? That case, the prosecution of the Trump Organization, resulted in Donald Trump's namesake, his business that he controlled, that he, ruled with an iron fist. They were convicted criminally by a jury in New York of 17 felony charges for being run basically as a corrupt enterprise. They were convicted of a 15-year-long criminal scheme to defraud in the first degree. I'm still looking for Donald Trump to be indicted for those crimes, hopefully sometime in the near future, but let's get through one criminal prosecution of Trump at a time. And it looks like Judge Merchan is up to the challenge. It looks like he is prepared to begin the trial just a couple of weeks from now, March 25th. And given that the evidence appears strong, at least in as much as we've seen in the public reporting, the evidence that has been amassed against Donald Trump, including an audio recording of he and Michael Cohen agreeing to commit these crimes, Donald Trump should be held accountable by that New York jury, because justice matters. Friends, as always, please stay safe, please stay tuned, and I look forward to talking with you all again tomorrow.